Thank you very much, Judge Benjamin, for being here today.
Thank you.
Let's talk about your approach to reading statutes, to construing them. How much weight do you give to the plain meaning of the text of a statute when construing it?
Thank you, Senator. In considering a statute, the first thing that the court must consider is if it is clear and unambiguous. If it is clear and unambiguous, the analysis stops there. If it is not, I would then, the Supreme Court has said that it is appropriate at that point in time to consider the text once again, the principles of statutory construction, and also that it is appropriate at times to consider legislative history.
Okay. And when we talk about the plain meaning of statutory text, are we talking about the plain meaning as of the moment of enactment, or does the time in question and therefore the meaning of the text in question evolve based on changing social conventions, social norms, linguistic conventions, and so forth over time?
I believe that it's gaining an understanding at the time that it was adopted.
The time of enactment. Now, you were the judge assigned to a sentence reduction petition in a case called South Carolina versus Staten.
Yes, sir.
I hope I'm pronouncing that correctly. It's a case that involved a defendant who had been convicted of murder. He was serving a prison term sentence, a minimum mandatory term of 30 years. As I understand it, you decreased the sentence of the defendant to 28 years rather than 30 years, based on some assistance that he had rendered to the police, to the Department of Corrections officer who was assigned to a case. You did this even though South Carolina's murder statute clearly states that no convicted defendant is eligible for parole or for early release or for good time credits of any kind under these circumstances. How did you decide that early release for that defendant was appropriate in spite of the statutory language?
Thank you, Senator. In considering that statute, I looked to the statute. I considered that statute was enacted after the mandatory minimum statutes. The statute specifically states that the motion can only be brought on the motion of the state or the prosecutor or the attorney general. That motion came before me on the motion of the state of South Carolina based on the Department of Corrections request for a reduction in the sentence. And I believe the captain of the Department of Corrections exact statement was that the defendant had unequivocally saved the lives of corrections officers. The title of the statute is titled Assistance to Law Enforcement or Department of Corrections. Our Supreme Court has stated that it is appropriate for courts to consider the fact that the statute, that the legislature was aware of other statutes at the time that they enacted the statute, and nowhere in the statute did it discuss mandatory minimums.
Is there any reference in that subsequently enacted statute that directly references crimes that carry those statutory minimums?
No, there was not.
Yeah, and that's what concerns me, is that the statute in question, the statute that I believe bound you, states, quote, no person sentenced to a mandatory minimum term of imprisonment for 30 years to life pursuant to this section is eligible for parole or any early release program, nor is the person eligible to receive any work credits, education credits, good conduct credits, or any other credits that would reduce the mandatory minimum term of imprisonment for 30 years to life required by this section. And so when there's a statute that's that clear, if there is then a subsequently enacted statute that makes no reference to a mandatory minimum sentence, seems to me to be a stretch to do this. And yet you've acknowledged that there's no reference to that statute. In other words, there's nothing that supersedes that.
No, Senator, the only thing that I can tell you is that in that statute, that the substantial assistance to law enforcement statute, the General Assembly gave great deference to the prosecutors in the state and also to the Attorney General to bring the motion. That motion cannot be brought by anyone else. It was brought to me based on the motion of the state of South Carolina to reduce the sentence based on the substantial assistance. The case law in South Carolina says that our Supreme Court has instructed trial judges to assume that the General Assembly was aware of the subsequent statute at the time that they enacted the new statute, which would have been the substantial assistance statute.
Okay. I see my time's expired. Thank you, Judge.
Thank you.
Judge Benjamin, how